Appeals, Division 1, is now in session.
Thank you. Please be seated. This is the time set for oral argument in the case of Weatherilt versus Moore, our civil number 15-0143. Each side will have 20 minutes within which to make their arguments here this morning. Appellant may reserve some portion of that for rebuttal. However, it's up to you to keep track of your own time in that regard. We've read the briefs. We've been through the record. We've actually conferenced this case this morning, so we're familiar with the underlying facts and the arguments, at least advanced in the briefs. As you approach the podium, I'd appreciate it if you would identify yourself and your client for purposes of our record. We are recording this both by audio and video, and if you're really interested, in a couple of weeks you can go to YouTube and look at the oral argument. With that, counsel for appellant may proceed.
My name is Kyle Sherman. I represent the appellants in this case, who were Mr. Weatherilt, who was the pilot of the plane at the time of this accident, and Mr. Harvey, who was the owner of the plane at the time of the accident. The substance of this appeal is generally about fairness. The concept of getting one's day in court really has no meaning. It's not worth much unless the rules establishing fairness, such as the rules of procedure and the rules of evidence, are both uniformly and effectively applied. That wasn't done in this case. Whereas in a case like this, irrelevant and prejudicial evidence is permitted to take center stage in a party's case in chief, all concepts of fairness have effectively been thrown out the window at that point. As outlined in the appellant's brief and reply brief, there are three major issues involving irrelevant and prejudicial evidence that was admitted to the jury, which we submit requires a reversal and a new trial. The first has to do with the airworthiness certificate arguments that were presented by the defendant and his counsel. Second is with regards to a defendant's expert's testimony who testified outside the scope of his disclosure at the time of the accident, and also included a great deal of information that had to do with the first issue, which is the airworthiness certificate arguments. And the third has to do with a direct and misleading reference to insurance from the defendant to the jury during the trial. As to the first point concerning the airworthiness certificate arguments, the facts both before and at the trial established that the airworthiness certificate was acquired by Mr. Harvey legitimately. The governing body behind investigations or behind the admittance or submission of airworthiness certificates for a plane like Mr. Harvey's, which is the FAA and which is the only body authorized to make such determinations, had already investigated prior to litigation as to whether or not Mr. Harvey had done anything wrong, and had found that he had done nothing wrong. He was actually...
Counsel, I mean, this issue was one that was debated in front of the jury. I mean, your client got to say,
yes,
I didn't do anything wrong, and I signed where they told me to sign, and the other side got to say, no, here's what the regulation says, and you weren't in compliance, you weren't the builder.
I agree.
And the issue of whether a valid airworthiness certificate was an important one as it related to the resale value or the damage recoverable on this plane, wasn't it?
I actually disagree with that, Your Honor. The concept of damages in this particular case required that the defendant, if he were found liable, would have to put the plaintiff back in the position that he was prior to the accident. The airworthiness certificate and the recertification issues had to do with after the accident happened. Those issues only came because of the accident actually happening. The only issues with regards to the damages should have been what the value of the plane was at the time of the accident versus how much damage had occurred afterwards. The airworthiness certificate, as it was presented to the jury, and I agree, it was presented to the jury, but wrongfully so. It had nothing to do with the damages, and there was no connection that was ever made to the damages.
Well, how can the challenge to the appropriate issuance of an airworthiness certificate and the costs that would have been incurred if in fact it was found that it was not properly issued and the whole plane had to be broken down and rebuilt by someone who could then file the request for the certification, how is that not establishing the value of the plane?
When put that way, I certainly agree with Your Honor. However, it was not a jury fact to determine whether or not a recertification could have been made to that plane. The only body allowed to make that determination is the FAA, and the FAA had determined prior to trial that no mistakes, no errors, no wrongdoing had been done by Mr. Harvey in obtaining his airworthiness certificate.
I was under the impression that an FAA, and counsel, I might ask you to address this when you get up, that an FAA official had said that they would not have made the recommendation or they would not have endorsed the application for the certificate if they'd known he hadn't worked on the plane. Is that not true?
No, Your Honor. The individuals who had testified at trial on behalf of the defendant were not FAA officials. They were individuals who were hired by the defendant to come in and testify to those remarks. However, the one individual who was an FAA certified or FAA related was on the plaintiff's side and had very clearly stated that because of a policy that the FAA had initiated, Mr. Harvey was grandfathered in and there was no determination. The FAA had investigated this, and by the way, it was the investigation only took place because defense counsel during the trial or prior to trial had initiated to attempt a tactical advantage over, had initiated that investigation with the FAA. The FAA investigated and determined themselves no wrongdoing had been done by Mr. Harvey. Whether or not an individual came in to testify, they were not related to the FAA, they were not working for the FAA, and they had no authority from the FAA to come in and say to the jury that Mr. Harvey had done anything wrong.
I thought the defense called Mr. Miller, and Mr. Miller had been with the FAA for many years, and he testified, keeping it simple, to the contrary, that the Mr. Harvey had either misrepresented or mistakenly certified that he was in fact the builder of the plane.
Mr. Miller, yes.
So he was a former FAA
Your Honor is correct.
Authorized.
He was a former. However, he was not part of the FAA. He was not working for the FAA.
That I understand, but doesn't it go back to Judge Winthrop's question, which is this was an issue for the jury to sort out because it did, at least as Judge Jones also mentioned, affect damages.
I would disagree with that, Your Honor, because number one, the jury had no jurisdiction to be able to determine whether or not Mr. Harvey had done anything wrong.
I know, but they had jurisdiction to figure out and determine damages.
Correct.
And they had to have some way to do that.
Correct. And the damages that were to be measured were going to be according to what Mr. Harvey's position was prior to the accident, not after the accident.
Counsel, I'm not sure I'm following that, because your client actually testified at trial that while he initially had paid $70,000 for this airplane, it was really, as a result of this crash, it was only worth $45,000, and that's what he was recovering. And one of the reasons I think it was worth only $45,000 is because it was damaged. It was going to have to be rebuilt. It was going to have to be rebuilt by somebody who would qualify for that certificate. So am I missing something here?
No, Your Honor. As far as what you have stated, that is correct. However, the point being is that Mr. Harvey was in a certain position prior to the accident. Mr. Harvey would not have been in that position to have to sell the plane at a lesser value had that accident not taken place. The issues that took place, or the issues that were tried upon or were supposed to be tried upon, were whether or not Mr. Moore, as a mechanic, failed to notice cotter pins that were missing from the elevator shaft that was in the plane. Had those cotter pins been in place, the elevator shaft would have worked at the time that the pilot was landing. The crash would not have happened, and Mr. Harvey would not have been in a position of having to sell a crashed plane.
Well, you didn't have to sell the plane at all for purposes of this lawsuit. The question was simply the amount of damage that had been sustained, what was going to be required to restore it.
Correct, and I would agree with that. And the difference between that would have simply been the amount that he paid for it versus what he was willing to sell it for in a crashed position, which was going to be at least $45,000.
But doesn't that then it's the market value of a damaged plane, and market value is typically measured by what a willing buyer would pay a willing seller, that they're not under duress and so forth. And doesn't that evidence then become relevant, because it's highly unlikely that there's going to be a willing buyer to buy this plane in its post-accident state, because that buyer would have to disassemble it and rebuild the entire plane. And that will have a impediment, or perhaps it will be off-putting to most buyers. I mean, that's kind of the import of this evidence.
For purposes of this argument, I would certainly agree with that statement. Okay, I think that I've gotten a little off topic. The point that I'm trying to make here is with regards to the testimony that was given with regards to this airworthiness certificate. How Mr. Harvey obtained the airworthiness certificate was already decided by the FAA prior to litigation. The problem is that the defense counsel used that as a ways to simply malign Mr. Harvey, and used it as a way to make him look bad. Even though Mr. Middlebrook, at the time of the litigation, had direct information, because he had initiated the investigation through the FAA. He had information in his possession prior to litigation that the FAA had determined that Mr. Harvey did absolutely nothing wrong in obtaining that initial airworthiness certificate. Now, had the defense counsel made a connection between the airworthiness certificate after the accident and the damages, that would have been relevant, and I will submit that for purposes of this argument. The problem is that connection was never made. The entire time was spent on maligning Mr. Harvey as to how he obtained the original airworthiness certificate, and that had already been determined by the FAA. He did absolutely nothing wrong, and yet that was allowed to take center stage in the defense counsel's case in chief, just to make Mr. Harvey look bad. The second issue regarding the scope of Mr. Wood's testimony, the defendant's expert. There were essentially two primary purposes for Mr. Woods being engaged as an expert witness, according to the defendant's Rule 26.1 disclosure statement. First, to further the defendant's argument.
Counsel, can I ask a question?
Yes.
Because I looked for this. The defense disclosure statement on expert witnesses, is that somewhere in the record? I could not find it.
Your Honor, honestly, right now I do not know the answer to that question.
Did it exhibit at trial? I didn't see that either.
Apologize, Your Honor, I do not know.
Okay, I mean, it's kind of an issue, because if it's not in the record, there's not much we can do about it. In other words, we can't compare this testimony against a disclosure that we haven't seen and can't see, if you understand what I'm saying.
Understood, yes. Mr. Pearson, however, did make objections during trial with regards to the scope of the testimony that Mr. Woods was given at the time.
I understand that, but in looking at those objections, again, I didn't see a reference to an exhibit. There's a reference to the disclosure statement, but there's nothing for us to look at to see what that says. So how can we really evaluate whether the opinions given exceeded what was disclosed, other than the fact that there was objections.
I would agree. If that's not part of the record, that is going to be difficult. I apologize, Your Honor. I'm not aware as to whether or not it is or is not part of the record at this point.
Thank you.
Okay. If that is the case, then I will move on at this point. Because the third issue that we do have is with regards to a reference to insurance. There was, as a premise, Rule 411 of the Arizona Rules of Evidence prevent the use of evidence that a person was or was not insured at the time of an accident. And I'm confident that it's well known that we don't want a jury being prejudiced either for or against a party because insurance was or was not involved.
That rule is generally designed to preclude the introduction of evidence of liability insurance.
Agreed.
True?
Agreed that is specifically within the rule of the language. However, reference to insurance in any form, and to my understanding, is inappropriate unless it's being used for purposes of showing ownership, showing that basically, or to contradict, that it's being used in contradiction of somebody's statement. However, in this case, it was used specifically for prejudicial reasons. This case, the jury was directly exposed to information that was misleading as to whether or not insurance coverage was available. The jury made it clear during the plaintiff's case in chief that they were concerned about insurance and whether there was insurance coverage available on the plaintiff's plane when they presented a question to the plaintiff as to whether or not that information was going to be available. Now, Judge Ray, after the question was presented by the jury, obviously didn't allow that question to be read, didn't allow it to be answered. And even though Judge Ray at that point had given the instruction with regards to insurance information to the jury, afterwards, Mr. Moore made a direct reference to insurance. And it wasn't a harmless reference.
Well, wait a minute. Wasn't it that the insurance company was requiring the wreckage to be relocated back up to Sedona or something like that?
See, and that's actually the problem. The jury had already made their interest in insurance clear, that there was going to be insurance. The problem is that there was no insurance coverage available on that plane for the time of the accident.
Are you talking about liability coverage, or are you talking about insurance in regard to the loss of the plane itself?
I'm talking about both, Your Honor. There was no liability insurance, I apologize. There was insurance available for the plane as it sat on the ground and in the hangar. There was no insurance available for the plane for the accident itself. And damages to the plane were a very big part of this accident. And the jury had made it clear that they were interested in whether or not insurance was going to be available. The judge at that point had given an instruction basically saying, you know what, usually I give this at the end, but I'm going to go ahead and read it now. He read the instruction to the jury saying that insurance information was not to be taken into consideration. Even after that instruction had been given to the jury, the defendant directly referenced insurance. And it was not a harmless reference because it gave the impression that there was insurance coverage available for this accident when there was not.
But it was a factually accurate statement that it was being relocated back to the Sedona hangar because that's what the insurance required.
No, Your Honor, that's incorrect because Mr.
Help me out with that.
Absolutely. Mr. Harvey, and unfortunately, we weren't allowed to give a curative instruction with regards to this. Number one, that conversation never took place. There was no conversation between Mr. Moore and Mr. Harvey that said that where Mr. Harvey made any type of comment that said insurance wants this moved. Okay, and second of all, insurance was not even involved because Mr. Harvey had no insurance for the damages to that plane at that time. That conversation never took place. So that the fact that Mr. Moore turns around and in his testimony after the judge had given the instruction and apparently even after his own attorney had told him not to reference insurance, makes a direct inference to insurance and gives the impression that there is insurance coverage after the jury has already made their determination that they're interested in insurance, is very prejudicial to the plaintiffs in that case. Because then it gives the jury something to look at that they shouldn't have looked at in the first place. Your Honors, I see that I have 1 minute, and I would like to reserve the rest of my time.
All right, thank you. Moore?
Good morning, Your Honors. My name is Jerome Moore, and I represent Patrick Moore and Kathleen Moore, defendants in this case. The crux of this case, the most important time, is that between November 15, 2010 and January 28, 2011, when the crash took place. Patrick Moore did the third annual inspection on the Harvey airplane on November 15, 2010. He testified that he did it properly, that he worked from a standard list that he uses in making sure that he covers all aspects of the plane so that he can correctly certify at the end of the inspection that it is airworthy. He said that he did follow his usual practice and that he correctly described the plane as being airworthy when he finished. Now, Mr. Harvey, according to the record, did not fly his plane at this period of time, but he did allow Mr. Weatherelt, the co-plaintiff, to use the plane for instructional purposes on 10 days between the time of that final annual inspection and the accident. Mr. Weatherelt testified that he found nothing wrong with the operation of the plane during those 10 days of his giving flying instructions. He said that when he came out to Sedona on the 28th of January to take his planned trip down to the Phoenix area, he checked the operation of the plane, found nothing wrong, and in fact everything was fine until he had risen to about 8,500 feet above Sedona.
Mr. Moore, I appreciate your recitation of the facts. We're pretty familiar with them and what the testimony was. What I'd really like to hear is you respond to Mr. Sherman's arguments that the continuous and repetitive testimony concerning Mr. Harvey's application for this airworthiness certificate was injected irrelevant and ultimately prejudicial evidence in front of the jury that swayed it from the issues squarely in front of them.
I'll be glad to do that. I did note your observation at the beginning, Your Honor, that you have read the record, and I trust that you have. And I'll shorten my argument as you suggested.
I think we're particularly interested in your comments with respect to that issue. So if you bear that in mind, I'd appreciate it.
Yes. I think the jury had ample evidence to find that the plaintiffs had not carried their burden of proof, that there was either negligence, as claimed by both plaintiffs, or a breach of contract. And again, I'll just shorten my reference to what was shown in the brief. There were some unexplained things during the course of the trip from Sedona down to the Phoenix area that would give rise to doubt on the jury's part that there was anything wrong, and that it in fact was an uneventful trip from Sedona down to Phoenix, and the trouble only began at the time Mr. Weatherelt brought the plane in for a landing at Buckeye. Now, Up until that time, the jury, I'm sorry, I got a little bit off the track here, Your Honor. Mr. The judge had ruled that there was no causation issue as to the airworthiness, but airworthiness, certainly the defendants were entitled to bring out evidence showing how it affected damages. Now,
I guess the question I have, Mr. Moore, on that is that Mr. Harvey checked he was the builder back in 2007
that's correct.
when he bought the plane.
Yes.
Okay, that's 2007. But by the time this plane went down and thereafter, the FAA had determined that he had done nothing improper and grandfathered him in, so that the FAA, as I understand the facts, had basically determined he hadn't done anything improper, and they were not going to pursue any penalty against him. Therefore, it is true that airworthiness as of the date of the accident and thereafter might affect damages, but why then is all of this stuff that happened back in 2007 relevant? The damages.
In 2007.
Right, when he purchased the plane, which is, I think, what we're trying to focus on.
Well, Your Honor, that actually is, I don't agree that there was any finding that he had done nothing wrong. I think the reference was to a proceeding with the FAA saying that the certificate of airworthiness was improperly issued. Now, that ended when Mr. Harvey turned in his certificate. So it was not a finding that nothing was wrong, but simply that the certificate is now turned in, we're back to ground zero, and we're not going to proceed any further. It was a useless thing at that point. But there was...
The FAA, forgive me, in your 1 minute perhaps you can clarify. So the FAA did not, in fact, let me put it this way. The state of the record is that the FAA simply just dropped the matter because Mr. Harvey turned in his certificate. So it just dropped. That's the state of the record?
Yes.
And it did not, and so the state of the record is that it did not clear him, so to speak?
No, simply that we have no reason to go further with this.
Okay.
May I ask a question trailing on that then?
Sure.
I didn't mean to cut you
No,
off.
I'm finished, yeah.
All right. If the certificate was turned in and the FAA said, okay, all wrongs have been made right, he's no longer flying this plane that he didn't put 51% of the work into constructing.
Right.
Does that then, for purposes of damages, which is why we raised this in the first place, does that then undo the fact that someone who subsequently bought that plane would need to tear it down to nuts and bolts and start over so they could get an airworthiness certificate asserting that they had done 51% of the work?
I don't believe that is the case. I think that my understanding of the record, Your Honor, is that if that plane is again presented for certification,
right,
a person has to verify to the FAA that they have done 51% of the work.
Right. So if we're looking at the issue of damages,
yes,
then there is a value, I assume, in regard to that, the wreckage of the plane, if you will, because it has other damages beyond the simple fact that the person who did 51% isn't there to certify it. But in fact, the value of that plane is going to be reduced, not just by the damages when it was landed, but also by the fact that it's going to have to be completely rebuilt from the ground up in order to be able to get certified.
that's correct.
Thank you.
I do believe that the argument that you heard about the FAA clearing Mr. Harvey is based on, it's referred to in the brief as Exhibit M, which I think must be from a deposition, and I think it corresponds with Exhibit 34 in the court record. That was a publication from the FAA regarding experimental aircraft issued in, I believe it was September of 2009. The appellant is claiming that on pages 10, 20, and 24 of that exhibit number 34, this shows that the FAA has grandfathered, or however you want to describe it. And I think when you look at Exhibit 34, you'll find that's not the case. They seem to be fully supportive of the CFR requirement. That was, I believe, 14 CFR 21.191, which lays out that a person presenting an experimental aircraft for certification must verify that they have done the 51% of the work at least.
But that is sort of self-corrected if the plane is crashed.
Yes.
Because somebody's going to have to tear it down to nuts and bolts and start over.
That's right. And it will not be recertified unless the person can verify that they have done the 51% of the work.
So that does go to the issue of damages.
Yes.
Thank you.
It goes to damages. And I think in the course of the trial and in the course of the ruling on the motion for new trial, it's apparent that Judge Ray heard the arguments in addition to his own observations over 4 days of pretty intense trial. He understood the issue, and in his discretion, he said, this is proper examination and proper argument on the matter of damages, and it's legitimate advocacy on the part of the defendants. It's an issue on which both sides acknowledge that the standard of review is abuse of discretion. And certainly Judge Ray, an experienced jurist, has in mind all of the relevant factors, and he determined that there was no error, and I suggest that the record supports that. This court should agree and find that there was no abuse of discretion.
Counsel, can you take us to the issue of these insurance references?
Well, I agree with the observation that the court rule in question deals with liability insurance, which is not involved here. Any insurance reference had to do with casualty insurance, property damage insurance. Now, we pointed out in the brief that Patrick Moore's inadvertent reference to insurance was not even the first time it came up in the trial. But when Mr. Wetherill was testifying, he described that he had given some instructions to Mr. Harvey, and Mr. Harvey needed that so that he could get his plane insured. Nothing was raised at that point, but the jury had already heard the subject mentioned. When Patrick Moore raised the question of insurance, it was certainly inadvertent, and the trial counsel for plaintiff frankly acknowledged it on the record, saying to the effect, I know this was not intentional, and so forth. Now,
the comment that Mr. Moore made fabricated, or was it was it a legitimate response, just unfortunately included the word insurance?
It certainly was an honest statement of what he had heard. He said, I think the issue was, why were you moving that plane up to Sedona? And Mr. Moore said, Mr. Harvey told me the insurance company wanted it not sitting out there in an open field, but brought up to where it would not be subject to further loss or damage. I think in the brief, it's sometimes said, there was at least one reference to Mr. Moore said the plane was insured. That's not quite accurate. He said the reason he was taking it up to Sedona was Mr. Harvey wanted that done at the request of his insurance company. The argument is further made by the appellants that, in fact, that conversation between Harvey and Moore never took place. As I read the record, this might be taken out of a deposition. I don't find any such statement by Mr. Harvey in the trial transcript. So if in fact that is appellant's position, that Harvey said, I never said that to Moore, I don't think the record supports it. But in any event, the court sometimes deals with this insurance issue. Judge Ray did adequately. He gave the proper instructions. And again, the whole issue of insurance might have some bearing on damages if the jury ever got to that. But in fact, the jury only got to that first step and found that there was no negligence, there was no breach of contract, so they never proceeded to damages. Again, that was presented in the motion for new trial. Judge Ray considered the arguments, found that there was not anything for supporting a granting of new trial, and in that he did not abuse his discretion. I think another thing that is quite important is the fact that Mr. Wetherelt is in the nature of a silent partner in this appeal. The jury obviously found that there was no cause for action against Mr. Moore on the Wetherelt claim. There is no argument in either of the briefs submitted that Mr. Wetherelt's claim was at all contaminated by disparagement, whatever the nature of the complaint is as to Mr. Harvey. No reason is given in the briefs as to why that should be reversed as to Mr. Wetherelt. If the court were to ask the plaintiff's attorney on what basis should Mr. Wetherelt's finding of no cause for action be reversed, it would be an interesting answer, because there's nothing in the brief saying that he is prejudiced at all regarding whatever legitimate argument was being made on the Harvey claim. Now, the jury heard exactly the same evidence on negligence for both claims, the Wetherelt and the Harvey claim. It would be a very difficult argument to say that the jury legitimately found that Wetherelt had not proven negligence beyond a reasonable doubt. And then to say that on the same evidence, Mr. Harvey would have prevailed on negligence, but for all this distracting questioning regarding his incorrect answer as to whether he had done 51% of the work on his plane. I think that we have to presume that the jury did the job it's called to do, that it assessed the evidence. You've got to recall also that Mr. Harvey really had no testimony dealing with negligence or breach of contract. Maybe a slight exception to that. He did testify that he hired Pat Moore to do his annual inspections, and I think it's implied that he was testifying. He relied on Mr. Moore's experience as an A&P mechanic, and he expected him to do a good job. We can see that certainly. But he did not observe any of the inspections that were made. He did not observe any condition of the plane, specifically on the part that eventually became disconnected. There is nothing in the way of testimony by him that would deal at all with to show liability. Basically, what he was relying on was Mr. Wetherell's testimony as to what happened. Obviously, the jury did not agree entirely with Mr. Wetherell's theory and found no cause for action as to him. And I think that certainly that applies as well to Mr. Harvey. They did their job properly and never got to any issue of damages. So there's been no showing of reversible error here, and we would ask that Your Honors affirm the decision below. Thank you.
Thank you, Counsel.
Thank you, Mr. Moore. Mr. Sherman?
Judge Norris, just briefly to touch on the issue that you had addressed with regards to your questioning. The FAA did perform an investigation, and there was evidence presented that suggested that Mr. Moore had been, or excuse me, that Mr. Harvey had been found not to have done anything. He was grandfathered in, and there was a policy that was written by the FAA that suggested that that's the reason why that he didn't do anything wrong, because that was the policy.
And is that
of the
Exhibit
FAA.
34?
Yes, correct, Your Honor. Judge Jones, I would like to address just very briefly some of your questions, because I certainly agree with the concept that you're getting at with regards to damages. The problem is that there was never any argument with regards to the damages after the accident and how the arguments with regards to the airworthiness certificate applied to after the accident. If you take a look at the record with regards to those particular arguments, they were all focused on before the accident happened. And that's the inappropriateness that shouldn't have been allowed. And we're asking that the court reverse and grant a new trial. Thank you.
Thank you, counsel. Appreciate the arguments made here this morning. I will take this matter under advisement and issue a written decision in due course. And with that, we stand adjourned. Thank you.